honest, what we normally do. Good afternoon, everyone. Welcome to the Graduate Institute. Welcome to the annual update on WTO dispute settlement. Normally we have it a little later, so I'm expecting some more people to walk in. But it's a pleasure to have this traditional event again here at the Graduate Institute. It's a great honor to welcome all of our guests. And as usual, we are dividing the event in two. So the first part is to hear directly from the institutions involved, the chair of the dispute settlement body, the chair of the appellate body, on what happened in 2018. And then we'll have a more interactive discussion with a number of academics, practitioners following that. So I'd like to call on our first two speakers, Ambassador Sunanta and then Professor Zhao, to speak for about 15 minutes. We may have a short Q&A, and then we'll move to the second part. Ambassador, you have the floor.
Ladies and gentlemen, distinguished guests, good evening, and thank you very much for inviting me to speak here today. I would also like to thank the Graduate Institute for organizing this annual event. Margaret Atwood said that civilization is based on exchanges, on gift, trade, and loans, and revenges and insults that come when they are not paid back. It is not surprising that this avant-garde author was a woman. I am here tonight to speak about the dispute settlement body as the DSB chair for 2018, which was one of its most challenging years, yet we endure. The DSB is facing a unique situation, even contradictory. On the one hand, the ongoing impasse on the appointment of the vacant appellate body members questions the survival of the dispute settlement as we know it. On the other, dispute settlement activity has been on the rise, emphasizing the WTO members' reliance on the system. This somewhat contradictory situation has seen DSB activity significantly boosted during 2018. The DSB has been the forum that held most of the discussions concerning the appellate body crisis. This was against the backdrop of another crisis that some like to call the trade war, triggered through a range of policies that members have put in place, several which, along with the responses to which are now the subject of WTO dispute settlement processes in themselves. The length of the DSB meetings has beaten records. In October and November of 2018, we had the lengthiest sessions of the DSB history, with 21 and 24 items on the agenda respectively. While on the one hand, some members challenge the efficiency and legitimacy of the WTO dispute settlement system, on the other hand, and at the same time, the number of dispute settlements brought to the DSB have continued to increase. Allow me to bore you, but only very briefly, with some statistics. I know that there are no one's favorite on this statistic issue, but they allow us to have perspective on the magnitude of the dispute settlement workload. In 2018, the DSB was notified of 38 requests for consultations and established 33 panels. This already implies that increase of 44% for consultations and of 69% for panels established from 2017. In absolute terms, 2018 has been the year with the most panels established in the history of the WTO dispute settlement, and the year with the most requests for consultation since 1998. The numbers are equally impressive for panel adoptions and active proceedings. In 2018, the DSB adopted 9 appellate body reports covering 6 matters, and 18 panel reports and 1 arbitration decision covering 19 matters were circulated. On average, 42 proceedings were ongoing each month, comparing with 38.5 in 2017. That makes 2018 the most productive year in terms of active proceedings. It is worthy of mention that the disputes on steel and aluminum and additional duties brought at least 15 panels. Importantly, participation in the dispute settlement system is becoming broader and more diverse. The average number of third parties participating in the dispute has risen to 18, which already implies an average increase of 33% in comparison with 2017. This massive increase in third-party participation is yet another sign of strength of and the support given to the dispute settlement system. Out of the panels which were established in 2018, 68% of complainants were developed members, as were 72% of the respondents. This means that 28% of complainants and 32% of respondents were developing members. There are changes also in the panelists who work on panels. 70% of panelists who work on panels in 2018 came from developing countries. Nevertheless, developing members' participation in the WTO dispute settlement remains low. It is without doubt that the very existence of the dispute settlement system itself is to ensure that WTO rules are faithfully implemented. Therefore, it is also an interest of smaller countries to secure the proper functioning of the appellate body and the WTO dispute settlement system. The current situation of WTO's dispute settlement mechanism draws more attention from members who believe and trust in the multilateral rule-based trading system. Regrettably, the appellate body crisis has threatened to paralyze the mechanism of resolving international trade disputes that we have successfully built and confidently relied upon for more than 2 decades. A proposal to launch the selection process to fill the vacancies in the appellate body has been tabled to the DSB's consideration for more than a year, even before I assumed the chairmanship of the DSB. During the past year, I have been conducting several informal consultations on the issue of possible reappointment of one appellate body member whose term of office were to expire on 30th of September 2018. My door has also been opened to several delegations that have been part of broader good faith efforts to resolve the impasse. Unfortunately, the DSB was unable to agree to reappoint that appellate body member. It is also regrettable that no consensus was reached to launch new selection processes to replace 4 appellate body members. In order to better understand the implications of the crisis, I would like to provide some certain background to those who may not be familiar with the issue, and I hope that those who know the issue well do not mind to revisit the subject. The appellate body is composed of 7 members. 3 appellate body members are required to hear an appeal as a quorum and make a final ruling. In the beginning of 2017, we had a full composition of 7 appellate body members. On 31st December 27, we were left with 4. On 1st October 2018, the number was down to only 3. The bare minimum required for each appeal. If the appellate body impasses continue, there would be only 1 appellate body member left in the office by 10th of December this year. The result would render the appellate body inoperable due to insufficient number to discharge the functions at the appeal stage. Against this background, together with some concerns raised on the systemic issues, the General Council appointed Ambassador David Walker of New Zealand as a facilitator to conduct the informal process under the auspices of the General Council on matters related to the functioning of the appellate body. These informal processes have been convened in a range of formats based on solution-oriented spirit. The aim of these informal processes are to actively and constructively review and discuss the concerns raised, issue by issue, and to provide an opportunity to hear new or alternative proposals, concerns, and other ideas. Ladies and gentlemen, as I mentioned, this year is a challenging year for the dispute settlement system. In an attempt to solve the impasse, I observed the endeavors of several members to put forward proposals at various occasions. As the DSP chair, I would like to reiterate the necessity of the constructive engagement by active members in Geneva and energetic participation from their capitals. This will lead to closer collaborations between officers here in Geneva and relevant officers at home. It is indispensable to raise the level of the engagement to include higher authorities in capitals to overcome the impasse with flexibility and compromise in mind. I encourage all members to join our collective efforts to find a common ground to unlock the impasse. Ladies and gentlemen, it has been a pleasure serving as chair of the DSP this year. I have learned a lot of dispute cases and faced unprecedented challenges. So I will not lie. Being the chair of the DSP has been very demanding. I have to admit that before assuming this chairmanship, I have never been aware of a gender-balanced panelist. This brings me to my last point. In the 34 panels composed last year, only 19% of the panelists chosen were women. And if we take a closer look at the WTO indicative list of government and non-governmental panelists, out of 434 names on the list, only 85 are women, which is over 19%. At the same time, more women panelists are often requested. Perhaps before I relinquish from the DSP chair tomorrow, hopefully, I have to put to members that it is their duty and obligation to close the gap. And one of the ways in which they can do so is by suggesting more women in the indicative list. Last but not least, I could have not chaired the DSP with ease, meeting after meeting, without excellent supports from the Secretariat. My special appreciations goes to Ms. Bojana Muller-Holist for her unwavering efforts for success DSB meetings throughout my chairmanship. I have witnessed personally that behind the statistics lies a strong belief that the dispute settlement system is one of the pillars of the WTO and that the membership wants it to continue to be so. A system that needs to remain inclusive and fair for all members. We need a strong dispute settlement system to be able to face 2019. I thank you.
Thank you, Ambassador Sonata. I think you make me understand the significance of my health condition beyond the end of this year will be more than to myself. Thank you for reminding me about that. Good afternoon, distinguished guests, friends, and colleagues. To begin with, I'd like to thank the Graduate Institute, in collaboration with the WTO Secretariat, for organizing this annual convention on the WTO dispute settlement. I appreciate the invitation to me in my capacity as the current chair of the appellate body to speak about the development and challenges of the appellate body in 2018. By all means, 2018 was a remarkable and challenging year for the appellate body and the whole WTO dispute settlement system. The hardship stems not only from the protracted backlog of appeals confronting the appellate body, but also from the reduction in numbers of sitting appellate body members to review such cases. At the same time, the complicated disputes on contentious and sensitive issues continue to flood in, and the institution is under unprecedented pressure and being strained to its limit. This situation has never been experienced in the history of the dispute settlement at the WTO. Looking back to the 2018, with the unabated support from the members of the WTO and the diligent work of the appellate body members and the secretariat staff, the appellate body has delivered its rulings without compromising on quality. Throughout 2018, the appellate body has been engaged in appeals and had circulated 9 appellate reports concerning 6 matters, including the appellate body report in massive appeal in Airbus. The matters addressed by these reports involved the GATT 1999-1994 TRIMS agreement, the TPT agreement, the anti-dumping agreement, the SM agreement, and the DSU. These disputes dealt with sensitive issues ranging from prohibited and actionable subsidies, safeguards, animal welfare, the domestic taxation regimes, to trade remedies. The exceptionally large appeal in U.S. large aircraft, known as Boeing case, continued to occupy a significant portion of the resources of the appellate body throughout the last year. The Secretariat also assisted in arbitrator in the award concerning reasonable period of time of implementation of the panel and appellate body reports. In addition, 12 reports concerning 11 matters were appealed in 2018. Furthermore, 2 additional appeals have been filed in the first quarter of 2019. Therefore, currently, there are 13 appeals pending before the appellate body. These figures indicate members' unwavering confidence in the dispute settlement system, including its appellate process. In a nutshell, despite the current crisis, the heavy workload of the appellate body will continue for the days ahead. Needless to say, and is known to many, the tenure of the 2 of the 3 current appellate body members will expire on the 10th December by the end of this year. The appellate body will not be able to review any new appeals coming in after that date without the replacement of these vacancies. This could paralyze the whole dispute settlement system, or, as many may argue, lead it back to the old GATT era, when panel reports could be adopted only when both parties endorse them. Under the current DSU, if any member chooses to appeal a panel report after the above-mentioned date, that dispute settlement process could be suspended indefinitely if no breakthrough could be achieved on the current impasse by December of this year. This is more than just alarming. Fortunately, members of the WTO are actively and earnestly seeking to resolve this impasse. A number of proposals were put forward by members and groups of members to the DSP and the General Council throughout last year. As noted by Ambassador Sonata, the WTO members discussed a number of substantive and procedural concerns regarding the functioning of the appellate body at both formal and informal sessions of the DSP and the General Council in 2018. Moreover, starting in January 2019, under the auspices of the General Council, Ambassador David Walker of New Zealand has been assisting the chair of the General Council as a facilitator to lead an informal process of focused discussions on the appellate body matters. Needless to say, the resolution of the concerns pertaining to the appellate body requires the political commitment of all WTO members. The famous saying in multilateral negotiation is, "Wherever there's a will, there's a way." Personally, I don't believe that technical issues concerning the appellate body cannot be resolved. In fact, I'm confident that current process will benefit from members understanding each other, narrowing differences, and eventually striking a deal to break the deadlock. Given the early stages of the discussion among members and being chair of the appellate body, I won't elaborate on the issues and the discussion today. The appellate body believes it is the WTO members' right and obligation to take their decisions about the future of the WTO dispute settlement system. The appellate body remains ready to assist entire membership in settling their disputes under the core agreement. We are well aware of our duties and responsibilities, and we will fulfill them within the mandate according to the rules set out forth in the DSU, impartially and faithfully. Having discussed the development pertaining to the appellate body of last year, I will now take this opportunity to speak about some broader perspectives of the history of international adjudication. As a background for the delegations, the academia, and the public in general to consider how to unlock the current crisis of the dispute settlement system at the WTO, as this is the very rare opportunity for me as a chair of the appellate body, as a member of the appellate body, to have the opportunity to communicate to the public. I would like to say something from my perspective, a historical perspective. First, from war to peaceful settlement of disputes, a milestone in the history of human civilization. The English philosopher Sir Francis Bacon said, "Histories make men wise." History seems to show that it was not unusual that war and armed conflict had been used to settle disputes among nations for a long time. That some international scholars of the 19th and early 20th century were of the view that international law exists solely or mainly in order to make war a human and gentlemanly occupation. Statistics indicate that the estimated number of casualties of armed conflict in Europe between 1800 and 2016 was over 3.5 million, and the death toll of the two world wars alone accounts for over 54 million in Europe. At the same time, that is why the studies believe why the European need EU is because of this. At the same time, dispute settlement in a peaceful, civilized manner, such as through Third-party mediation, conciliation, arbitration has been tried and practiced for many centuries. In Europe, arbitration, as practiced among Greek city-states and communities within Roman Empire, was advocated for by professors Hugo Grotius and Émeric de Watteau as an effective peaceful means of dispute settlement among nation-states. As one of the famous international law theorists of his time, Professor de Watteau regarded arbitration as, I quote, a practical, rational, and ethical means of resolving interstate disputes. Throughout human history in the East and West, it took a long time for nations to commit to subjecting themselves to a set of rules aimed at ending wars and maintaining peace. The solemn treaty between the rulers of Lagash and the Huma in ancient Mesopotamia around 2100 BC was the earliest document evidencing such efforts. In 1648, following 3 years of negotiations, the 300 parties to the Peace Treaty of Westphalia committed to a set of rules and principles recognizing the sovereignty of co-equal states, non-intervention, religious tolerance, and peaceful settlement of disputes through amicable settlement or legal discussions, thereby putting an end to the devastating 30 Years' War in Europe. This marked not only the birth of modern international law, but also of the peaceful settlement of international disputes, entering a new era, premised upon the widely accepted common values and the founding principles of the public international law. From today's global point of view, these were only regional peace frameworks. 7 decades ago, after the Second World War, a multilateral framework aiming at maintaining peace and security was created after the sacrifice of more than 40 million lives. Today, based on that framework, we witness the proliferation of hundreds of treaties and countless international legal documents in various fields. International law has become an essential pillar of the present international order. Maintaining peace and prosperity has become the ultimate goal and objective of international law in all domains. While material achievements of human civilization are physically visible, the invisible institutional achievement, though more precious, is sometimes easily ignored. After 7 decades, it seems that international dispute resolution has come to a crossroad, and it is high time to decide with the next step. Second, from arbitration to international adjudication, an orientation toward an international judiciary institution. As civilization progresses, the ways and methods of peaceful settlement of disputes among nations proliferate. Except for bilateral consultation, good official third-party mediation, conciliation, arbitration are all viable means of peaceful settlement of disputes among states. Remarkably, the rise of international adjudication as a prominent means of conflict resolution has become a monumental achievement in the peaceful settlement of disputes in human history. Academic studies show that the rise of international adjudication was closely connected with the peace movements in the late 19th century to the first half of 20th century. The establishment of permanent International Court of Justice in 1922, which was transformed into the International Court of Justice in 1946, represented the voluntary acceptance of jurisdiction of international courts. After the Cold War, 6 permanent international courts existed, along with the non-compulsory dispute settlement system of the GATT and European Court of Justice, which operates effectively on a regional basis. According to the Oxford Handbook on International Adjudication of 2014, currently there are at least 24 permanent international courts that have collectively issued tens of thousands of legal judgments. I omitted that number. The number quoted by that book on that page is 37,000. You can have the quotation from that book. More than 90% of these rulings had been issued after the fall of Berlin Wall. The greater influence of international adjudication today is not simply a matter of numbers. While the early international adjudication bodies were primarily invoked on voluntary basis, there has been a marked shift to compulsory jurisdiction, with non-state actors having access to some of those international courts. In general, the rise of international adjudication with compulsory jurisdiction elevates the institutionalization of peaceful settlement of disputes among states to a new level. Third, reassess the appellate body at the WTO its unique value. Among the more than 24 international adjudicatory bodies, the WTO appellate body is one of the very few that actively operates at appeal stage on a multilateral basis. The appellate body was established when the GATT multilateral dispute system was vested with the compulsory jurisdiction and a negative consensus rule in the DSU. The right to appeal was a compromise, ensuring institutional balance of the WTO members to accept such changed rules. It provides for a standing body comprising 7 members with recognized authority in international trade, elected by all members to serve on a fixed-term basis with representation from different world regions. The selection process has designed to ensure democracy and legitimacy to the composition of the appellate body. The 7 members have equal opportunity to form, by random rotation, a 3-member division to conduct a final review of the legal issues. Members appealed in the panel reports. If multi-level court system within the domestic judiciary regime represents the advancement of the justice to citizens of that country, appellate stage at the WTO represent a higher level of justice and fairness to the members of the WTO in dispute settlement process. The right to appeal a panel report is an entitlement of members that is enshrined in the multilateral trading system since the Uruguay round. The number of cases resolved by the system and the remarkably high rate of implementation are indicators for the effectiveness of the system. Having made those remarks, it should be emphasized that the appellate body never claims to be perfect. On the contrary, the appellate body members constantly recognize the need to actively engage in improving their practices, both in adjudication and internal management. The appellate body members are willing to listen to the concerns of the WTO members and are ready to respond constructively to the members' reform proposals once the DSB could reach consensus. The appellate body appreciates members' understanding of the chronic backlog cases on the one hand and the limited resources of the appellate body on the other. In response to concerns over lengthy and complex reports, the appellate body has introduced a brief summary of its findings in each of its reports for the past 3 years, and has significantly reduced the length of the reports when comparing with the previous years. The appellate body is open to further improvements and is always determined, to the best of its capacities, to provide adjudicatory service of higher quality to WTO members. This commitment has never changed and will never change. Let me conclude by emphasizing that the WTO dispute settlement system is at a historical juncture. While the international adjudication system has been created and serves the purposes of maintaining world peace, the weakening of such institutions run the risk of enlarging the difficulties and threatens the interests of all. Therefore, this is high time for the WTO members to take decisive action and to guide the future of its dispute settlement system. Thank you for your attention.
Okay, thank you so much. We can move now to the second part of the event. And I would invite the ambassador and Professor Zhang to take a seat over there, and the guests to join the... Sorry, no questions. Okay, wonderful. So now we can really get into some more details. And there's a lot happening, but we thought it would be useful to focus for once not on the deadlock of the appellate body or on the reform of the DSU, but to really look into what has come out of the dispute settlement system in the past year. A lot of very important reports, and very few people are reading them or commenting those reports, so we thought it would be useful to have a look at those. We chose a focus of subsidies, so we'll focus to some extent on some of the subsidy cases, and for that I have a panel of experts, diverse backgrounds. So on my extreme left, and you can see their names and bios and pictures, some of which are wrong, so sorry Natasha, on the screen and behind me. But on my extreme left is Quentin Baird from the Rules Division, which is fantastic to have. On my left is Hannes Welge from King & Spalding. On my immediate right is Natasha Spiesbach, who's with the Australian mission. And over there in the middle is Clotilde Duparc of Van Balen-Bellis. And of course, we couldn't miss an academic voice, so Luca Rubini is with us from Birmingham Law School. Now, that said, let me just remind you of some of the activity that happened. And I think we already got a very good overview from both of the chairs. When you look at the panel reports, and I think the ambassador pointed that out, it was an incredibly busy year. 15 reports were issued. And if I would have to take away 3 points about these reports is, first of all, it's a very high number. It's the highest number since 2005. Secondly, in 2017, there were only 5 reports issued, and none of them were appealed. Of the 15 issued in 2018, 13 were appealed. So strangely enough, there's a rush to the appellate body, even more so than before. The third point that I found interesting is that 4 out of the 15 reports were compliance cases. So the issue of compliance really is becoming more prominent. Now, we have the tradition not to discuss panel reports that are on appeal, because who knows what happens. But just to remind you of some of the big cases currently before the appellate body: Australia plain packaging, the EU energy package is also under assessment, a very sensitive case between Japan and Korea on radionuclides, which I think will come out tomorrow. But we won't be discussing those. We will look at panel reports that were adopted or appellate body reports. Now, if I look at the appellate body reports, as the previous speaker mentioned, there the number is not so high, only 6, which is similar to what was issued before. 5 out of the 6 were trade remedy cases, so that really pushed us to focus on subsidies, trade remedies. 2 out of the 6 were also compliance cases, and we will come back to it, but the famous aircraft saga, some people thought it was over, but if you've read the press yesterday, it isn't over. tuna dolphin, it's already the second time it was filed. It was a second 21.5 case, so that seems to be over. And then the last point that is really quite interesting, and the previous speaker mentioned it, page numbers have gone down of appellate body reports, which I'm sure my students here will appreciate, and many observers will appreciate, but the saying often goes it's more difficult, it takes more time to write a brief report, so the reports are shorter, but they actually take a lot more time. So the average is close to a year for an appellate body proceeding. So with this in mind, we discussed amongst ourselves what to focus on. We'll focus on the subsidy cases, but go slightly beyond that as well. And I'd like to start by giving the floor to Hannes on my left, because one of the cases that came out, appellate body reports that came out in 2018, relates to safeguards, relates to the very tricky question of when is a tariff, a duty, a safeguard? When does the safeguard agreement apply? And there's two cases that came out, and it won't be a secret that one of the big cases pending today also depends on that classification. Is the US steel duty a safeguard or a national security measure, or both? So Hannes, can you try in a couple of minutes summarize what these cases, because there's actually two, a panel report, India Steel, and then an appellate body report, what they've come out with and what they may mean for that big next case.
Thank you and good afternoon. So I'm talking about safeguards, and it's Indonesia Steel, and also about a panel decision, it's India Steel. And both cases were completely argued by the parties as safeguard cases. So they disagreed about whether rules of the safeguard agreement were respected or not. And then already the panel in Indonesia Steel started to have doubts whether that is a safeguard case. And they were looking at Article 11 of the DSU, where it says, a panel should make an objective assessment of the matter before it, including an objective assessment of the facts of the case and the applicability and of conformity with the relevant covered agreements. Well, that there has to be a legal basis for this. What you do is no real surprise for me as a former judge. Maybe it's a surprise in the dispute settlement system here, but for me it wasn't a surprise. So they started looking at that, and then they started asking themselves the question, what are the necessary elements of a safeguard measure? And they were looking at, no surprise, Article 19. And there in Article 19A1 at the end, the question of what you can do if the conditions in your view of safeguard are there, it says the contracting party shall be free to suspend the obligation in whole or in part, or to withdraw or modify the concession. Now that is the issue. Did they do that? And in Indonesia Steel, they found that Indonesia had done this safeguard measure for a product for which it has no binding in its schedule. So, and then the consequence for the panel was, if there is no binding in the schedule, there is no withdrawal of concession. And they came to the conclusion, if there is no withdrawal of concession, no matter what else you do, this is a necessary requirement, it's not a safeguard measure. And just to give you the result of this, actually they could have levied a higher duty, but they exempted 120 developing countries. And this exemption was not supposed to be removing serious injury. That's why also that could not be a safeguard measure. They found themselves of having taken a standalone measure which was discriminatory, and therefore they lost it. Now India also Steel, also the parties argued the case completely on the basis of the safeguards agreement, and India had a binding in its schedule, and the binding was around 40%. And they applied a tariff of, if I remember right, 12. And their safeguard measure was taken in a way that it was still below the 40. So the consequence could have been the same, but it wasn't. Because the gut is a complex animal. In Article 2, there is 1b, and there is a second sentence, and that said, such product shall also be exempt from all other duties or charges. Sort of the construction of this article is, you shall not take more duties than what is in your binding schedule, and you should also take no other duties and charges. So that's more or less the sense behind it. And actually, they asked themselves, well, is it this or is it a normal customs duty? And then they looked at it and they said, well, it is not a normal customs duty because it is not designed to be permanent. It is time limited, and it is decreasing as it is requested by the Safeguards Agreement. So it is then probably one of these other duties or charges falling under Article 2. And the last checkpoint they did was under Article 2.2 of the GATT, there could be an exemption from this exclusion, from this prohibition. And there is indeed an exemption for anti-dumping and for countervailing duties in 2.2, but there is no exemption for safeguard duties. So, long-winded conclusion was that this was a safeguard measure, and that was the decision of the panel for the time being. I think it's appealed, and that's basically all I want to say about that. Now, as Jost has already indicated, that's very interesting. So Article 11 of the DSU says you can or you should review the applicability of the legal basis. The appellate body went one step further. It said you must. Now the question is, do we have lessons to learn from this with regard to the 232? And in order to remain authentic, I'm trying to read just one sentence from the proclamation of the President of the United States, where it reads, are being imported into the United States in such quantities and under such circumstances, as far as that, the language sounds pretty much safeguard, and then it goes on, as to threaten to impair the national security. End of the story. And then just taking it as an example of all the countries which are subject to these duties, who declared these duties safeguard measures. These guys, safeguard measures, I take the notification of the EU, where it reads, notwithstanding the United States characterization of these measures as security measures, they are in essence safeguard measures. They consist of remedial action that disturbs the balance of concessions and obligations from the World Trade Organization agreement and restricts imports for the purpose of protecting domestic industry against foreign competition for the sake of that industry's commercial prosperity. Right, so they did that, and then they did rebalancing measures. Now, I think it might be useful to read out to you what the appellate body, and it is remarkable that the appellate body sort of went so in detail, what you have to do when you want to distinguish a safeguard measure from a non-safeguard measure. And I read that out in full, it's just one paragraph. In order to constitute one of the measures provided for in Article 19, a measure must present certain constituent features, absent which it could not be considered a safeguard measure. First, that measure must suspend, in whole or in part, a GATT obligation or withdraw or modify a GATT concession. We have seen that. Second, the suspension, withdrawal or modification in question must be designed to prevent or remedy serious injury to the member's domestic industry caused or threatened by increased imports of the subject product. So these are the two main conditions set up. And then it gives help to interpret that, to find that, and says, In order to determine whether a measure presents such features, a panel is called upon to assess the design, structure, and expected operation of the measure as a whole. In making its independent and objective assessment, panel must identify all aspects of the measure that may have a bearing on its legal characterization, recognize which of those aspects are the most central to that measure, and thereby properly determine the disciplines to which the measure is subject. As part of its determination of whether a measure is a safeguard measure, a panel should evaluate and give due consideration, where relevant, to the manner in which the measure is characterized under the domestic law of the member concerned, the domestic procedures that led to the adoption of the measure, and any relevant notification to the WTO Committee on Safeguards. However, none of these is alone determining, and so on and so on. So now, what does it help us? First of all, we need to consider that the situation for the United States 232 measures is reverse to the situation we have had for Indonesia and India. They both pretended they have taken safeguard measures and were told you haven't, while the US say we have taken something sui generis, and some other members tell them, no, 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 guys, you've done that, that's disguised safeguards in reality. So if the obligation under 11 of the DSU goes as far as saying you should not only check whether the claimed legal basis is the right one, you should also say, well, if you don't claim a legal basis, you could give it one. So that would be a necessity, but maybe it's academic, because in a panel which would have to decide against the rebalancing measures of the other members, they pretend they are safeguard rebalancing members, so it's probably gets us nowhere. But the point here is, if it came to it, and the panel would have to look at the structure of the measure and the measure as a whole, it probably would have to ask first, what is the background in the US? What are the institutions? What is the law on which that is done? It's not the US safeguard law, they have one. It is not the procedures which they normally would imply for a safeguard measure. It's not the ITC, it was the Commerce Department doing the report. Okay, it's the president with the same decision, that's the same. But the other thing is that, was it designed to prevent serious injury? Well, they might have had it in the back of their minds, but they didn't say so. In these reports on aluminum and steel, there is a lot said about the situation of the industry and injury to the industry, but is there really a finding of serious injury? Is the measure taken to remove serious injury? I must say, I would have my doubts on that. So if I look at that altogether, then I wouldn't easily come to the conclusion that these are safeguard measures, and within the WTO dispute settlement, they would find them being safeguard measures. For me, that is a notch too far. The consequence of that would be that if they are not safeguard measures, the measures of the others are not rebalancing measures. They both then stand there without a legal basis. Well, worse things than that. But I mean, tactically, for the participants, it might have been an advantage to be able to take quickly measures and not to have to wait for a dispute settlement decision before you can do something against it. So as often, this is a motivation which runs the people to take their decision here. So that's how far I wanted to go. It's probably more than 5 minutes, but anyway.
Okay, wonderful. So reading between the lines, you're quite skeptical then of these steel duties being safeguards. We can come back to it if you wish later on in the discussion, but I suggest we move to Luca now to look at another appellate body report, perhaps even a bit more technical even, the Brazil taxation report, because it does deal with a big issue of industrial policy. Many countries, I presume, want to promote local production, and the GATT WTO allows for that. You can subsidize to some extent, and you can limit your subsidies to your own producers. But where do you draw the line between that and a subsidy that favors domestic products over imports? So perhaps, Luca, you can give us a sense of the importance of that case and what you think of it.
Okay, first of all, thanks very much for the invitation. It's always a pleasure to be here, and I hope there will be many, many other years, not when I'm invited, of course, but many other years where we will all have the opportunity to comment on decisions of the appellate body in a critical way and in a constructive way. Let's give me some time to give a little bit of introduction to the case. It's very technical, so I do really try to skim a lot of the technical details and go and touch the key issues. What are we talking about in this case? There are various tax measures adopted by Brazil concerning various sectors, the ICT, information communication technology, automotive, and certain measures in favor of certain export enterprises. Now, all these measures have been found in one way or another to breach one of the fundamental provisions of the GATT and then the WTO, which is national treatment. GATT Article 3, Paragraph 2, so internal taxation, and Paragraph 4, internal regulation. And also, in some cases, to breach subsidy rules, and in particular, the most dangerous cases, so prohibited subsidies, and in particular, subsidies with local content requirements. Assume many of you know what we are talking about. I'm going to give you a subsidy if you're going to buy locally a certain amount of inputs. This is considered to be a subsidy with a special negative condition, which means that the subsidy is strictly prohibited. Now, the key point, I mean, there are various issues, of course, but in my view, the key point of the case, which merits some discussion here, is the general defense which is put forward by Brazil with respect to the negative findings of breach of national treatment, so principle of non-discrimination. And what is Brazil doing is basically suggesting that they benefit from an exception that you also find in Article 3, national treatment, Article 3, 8b. I will then try and stop with refer to numbers, but 3, 8b, which basically says that you don't apply, or better, Article 3 shall not prevent the payment of subsidies exclusively to domestic producers. To put in another way, Brazil is attempting to have a very broad meaning of this defense adopted by the dispute settlement, and a broad interpretation which would cover many cases of discriminatory internal taxation. They would like to tag them as this type of subsidies. So clearly, if the appellate body adopts this type of approach, there are a lot, potentially, not only in this case, of measures of internal taxations, which are somewhat discriminatory, that would be sheltered, covered, protected. So there are various issues that come out here. So what does this exception mean? What subsidies are included and excluded in this terminology? What elements of the subsidy measures are included? And more specifically, and I add a little bit of meat to the bone, there is an underlying issue here. Some of the measures of Brazil were also considered to be, as I said, prohibited export subsidies, local content requirement subsidies. So the underlying issue is about whether you can use this exception to national treatment to somewhat protect import substitution or local content subsidies, okay? So this is very much what we have. A final note before moving to what the appellate body found is that it's not partial what I'm saying, it's based on the law, but since 1947, local content requirements are prohibited. They are strictly prohibited. You may have various attempts via Article 20 of the GATT, general exceptions, to justify them. It's not easy. That's probably why now we assist this type of attempts to use this domestic subsidy exception under Article 3. Now, the appellate body. Interestingly, although all the three members of the division agreed with the final outcome, there was a dissenting opinion. So let's start with the majority, and then I will very briefly tell you what the dissenting voice said. The first step, the key step in the appellate body reasoning, remember the language, payment of subsidies. So one of the key issues is, what does payment of subsidies mean? Can we simply refer to the definition, of general definition of subsidies, which includes also taxation? Or is this language hinting at something else? Now, for the appellate body, the majority, payment of subsidy only cover expenditures, like grants. It cannot cover taxation, tax incentives. And this is the key element in the reasoning of the appellate body that then leads to their tripartite conclusion. The first thing, this domestic subsidy exception carves out subsidies that, because they are paid only to domestic producers, affect the conditions of competition in that market. It also carves out any condition for eligibility for the payment of the subsidies that define the class of eligible domestic producers by reference to their activities in the subsidized products markets. So we are always referring to the market at issue, which is covered by Article 3. What it does not carve out are the requirements to use domestic over imported goods to benefit from the subsidy. So in other words, local content requirements are not covered by this exception. Very briefly, I would say that I agree with this approach. It's clear that you have to distinguish the subsidy from the condition, a condition like a local content requirement, and that this is not really covered by this exception. As a conclusion, what about the measures for which Brazil sought protection? None of the measures were eventually justified. What is the difference that you have in the dissenting voice? As I said, the dissenting voice did agree with the final output, the final outcome, with the key thing that local content requirements cannot be justified by the domestic subsidy exception, but he or she adopted a different view with respect to the term payment of subsidies. In her or his view, this should also include taxation, so it should be particularly broad. If I have 1 minute, just for putting this decision in the broader picture. I said already that on its terms, legal terms, in my view, this is a very good decision by the appellate body, but it is also good if we consider the broader picture and, if you wish, the system. Let's just juxtapose a little bit the case law on subsidies and the case law on local content requirements and national treatment. Now, in subsidies, there have been few momentous and controversial decisions of the appellate body that have arguably narrowed the scope or the possibility of applying subsidy rules. I'm just referring to the infamous US AD/CVD and the definition of public body, the Canada Renewable Energy case and benefit analysis, the US tax incentives, and the test of contingency, which, like the test of contingency for ex post subsidies, is particularly demanding, but also possibly with respect to remedies. One case we are going to comment today, which is the EC Aircraft 21.5, and the very narrow interpretation of remove adverse effects or withdrawal of the subsidy. All this may mean that many people think that subsidy laws do not really bite as of now. If this is correct, and if the appellate body had also adopted a very broad definition of this domestic subsidy exception under Article 3, well, the final outcome could have been that many, possibly too many, subsidies or industrial policy measures would have escaped the application of WTO law. Maybe the very final point is that it's very interesting that in some cases, local content requirements have not been struck down in recent cases by subsidy rules, but by Article 3. And I'm referring, and the TRIMS. The Canada Renewable Energy case is one, and another one is the India solar case. So all in all, I would say this is a good decision, which I would say followed the lines of the previous case law, very orthodox, very traditional, but I think it's sound. Thank you.
Wonderful. Thank you, Luca. Luca, of course, is the author of an early but still very relevant book on WTO subsidies, which got translated into Chinese? Or?
It is going to be translated into Chinese and come out in the summer, yes.
Wonderful. So, by the way, that's another feature that is quite telling. Of the 6 AB reports that came out, in 2 you had a dissent, which is an uptick from what we saw in the past. I'd like to turn to Natasha, who volunteered to summarize the aircraft case, which is a challenge. And as we were talking, the second one, the Boeing case, also came out, and she said, okay, fine, just add a minute to it and I'll do it. But we discussed, obviously, that it would be useful as a bridge between Brazil tax and the aircraft cases to perhaps say a few words about that line we were talking about. And then if I can just push you to, especially also for students in the room, what are the kind of takeaway findings in these 2 reports, and where is this case going to move next? Natasha?
Thank you. And I should just mention that the comments that I make are in a personal capacity, not in a capacity as representing the Australian mission. So I think that, yes, as you said, I had volunteered to talk about the aircraft cases, one at a time, and then the second one landed, and I was given 5 minutes to cover these, so it won't be a very fulsome discussion. Rather, I'm going to distill a couple of the aspects that I think perhaps have broadest application rather than the ones that are very applied to the particular facts of those cases. And so there are 3 kind of questions or issues that I think it's useful to draw out of both of these reports. One is about issues relating to determining whether there's a financial contribution, which is the first part of determining whether there's a subsidy, and particularly with respect to when there can be said to be revenue that is foregone. The second issue is about what is required for a member to bring itself into compliance with Article 7.8 of the Subsidies and Countervailing Measures Agreement, and I am hoping that this will generate some discussion tonight. But I thought I might actually lead, following on from Luca's presentation, with the third issue, which is what is required to establish a prohibited domestic use subsidy. And as Luca mentioned, there are 2 types of subsidies that are prohibited under the SCM that are owing to their inherently trade distortive impacts. And that those are subsidies that are contingent in law or in fact upon export performance, and the ones that we mentioned this evening, subsidies contingent upon the use of domestic over-imported goods. And as Luca commented, the recent cases arguably set an extremely high bar for establishing contingency. Now, there's a reason for that, obviously, because the SCM draws this distinction between prohibited subsidies on the one hand and actionable subsidies on the other. And the view is that you can't have these 2 distinct categories be blurred by assuming that simply the effects of a prohibited subsidy are sufficient to establish contingency, when that's precisely why actionable subsidies are disciplined due to their effects. So there's been this desire to maintain this distinction between not focusing on the result of the subsidy in trying to determine whether that subsidy was conditional on in this case, the use of domestic over-imported goods, but rather looking at the terms of the measure itself, but also its design, structure and operation. And in these aircraft recent cases, as well as the conditional tax incentives case that Luca referred to, the baby Boeing case, there's a question over how high the bar actually is for establishing contingency. Because when you reflect on the inherently trade distortive impacts of those two types of subsidies, plus together with the appellate body's recognition in the baby Boeing case, that even though a prohibited domestic use subsidy doesn't prohibit the subsidisation of domestic production itself, it only prohibits the granting of subsidies that are contingent upon the use of domestic over-imported goods. But the appellate body recognised that domestic production subsidies can ordinarily be expected to increase the supply of the subsidised domestic goods in the relevant market, thereby increasing the use of those goods downstream and adversely affecting imports. So there's a recognition that domestic production subsidies ordinarily cause these trade distortive impacts, and yet there's a caution about not establishing contingency on that basis alone. Now, as some of us will be familiar with the facts of the baby Boeing case, I just want to reflect on the circumstances there about what the appellate body found it was not sufficient to establish contingency. And this was in circumstances where Boeing would have been ineligible for the relevant subsidy if it undertook any wing assembly for its 777X aircraft outside the state of Washington. So in circumstances where eligibility for that particular subsidy effectively required Boeing to incorporate domestic wings assembled within the state of Washington in its production of that particular aircraft, the appellate body was not satisfied that either the terms of the measure or its design, structure and operation were sufficient to reach this contingency test. And I think it's also useful to think back to the original Airbus appellate body report, where it was looking at the concept of contingency and de facto contingency, which is what's at issue here, with respect to prohibited export subsidies, the other kind of prohibited subsidy. And there the language was, again, the appellate body stressed, the standard for de facto export contingency is not met simply by showing that anticipated exportation was the reason for granting the subsidy. But the narrower standard that was articulated was whether the granting of the subsidy was geared to induce the promotion of future export performance by the recipient. And as part of that analysis, whether the evidence shows, all other things being equal, that the granting of the subsidy provides an incentive to skew anticipated sales towards exports in a manner that's not simply reflective of the conditions of supply and demand in the relevant market, undistorted by the granting of the subsidy. And in those circumstances, in those proceedings, the appellate body said that would be an indication that the granting of the subsidy is in fact tied to the anticipated exportation. So I wonder if, reflecting on that particular articulation, if we think about it in the domestic use context and we think about the circumstances of the conditional tax incentive case or other cases more recently where there's this view that perhaps this contingency standard is so high as to maybe be unable to be met, if the critical aspect is whether the granting of the subsidy plays an active or a live role in distorting or influencing the commercial decisions of the recipient of the subsidy, maybe in the conditional tax incentives case, the correct question is, was the granting of a subsidy requiring the domestic siting of the production of an input geared to induce the use or incorporation of that domestic input over an imported one by the recipient. So that's covering off on that sort of linked issue. I'll be very quick with respect to the first of the two others, because it's very straightforward, this question of when revenue will be said to be foregone, and this has been helpfully clarified in the Boeing 21.5, the US large civil aircraft compliance proceeding appellate body report. And the AB has clarified that the government revenue foregone refers to the government relinquishing an entitlement to raise revenue. So the focus is on the conduct of the government in providing certain tax concessions and not the conduct of an eligible taxpayer in using those tax concessions. So in this case, the fact that Boeing may not have actually used the tax concessions that remained available to it under the transitional arrangements didn't mean there had been no financial contribution for the purposes of the SCM. Because by giving up its entitlement to the revenue, that was sufficient. And I just note that also because when we move to the China domestic support, perhaps there are some parallels with looking at the quantity of eligible production, and that this covers all production that is entitled to receive the administered price, whether or not the production was actually purchased. Moving to the second issue that I highlighted and that Luca foreshadowed, about this finding about what's required for a member to bring itself into compliance with Article 7.8 of the SCM. The panel in the Airbus 21.5 had found that a member will only comply with its obligation under Article 7.8 if it no longer causes adverse effects through the use of subsidies, regardless of whether the subsidies themselves continue to exist. This was obviously appealed, and the appellate body has clarified that there is a critical distinction between the continuation of the infringing conduct, and the infringing conduct is a member continuing to grant or maintain a subsidy that causes adverse effects. And on the other hand, the continuation of adverse effects. It's only a member's conduct in terms of whether it continues to grant or maintain a subsidy that gives rise to a compliance obligation. And the continuation of the adverse effects themselves don't give rise to a separate compliance obligation, including because the appellate body did not understand how a member could give effect to that in relation to a subsidy that no longer existed. In this way, the appellate body has made clear that the remedies that are contemplated in Article 7.8 are not intended to restore a responding member's, they are intended to restore a responding member's conformity with its obligations rather than intended to restore a complaining member's competitive position. In my personal view, I think that this is the legally correct position. I think that it's the sound analysis based on the terms of Article 7.8 and where it sits in relation to and its interaction with the other provisions. But the question does arise, what does this mean for the effectiveness of the dispute settlement system to resolve disputes? And this isn't unique to the SCM agreement, as Luca was mentioning. This idea of prospective remedies only that aren't intended to restore a complaining member's competitive position does leave open this question of how effective the remedy is. And particularly though, in a case where the subsidies were found to be of such a quantity and such a scale that the industry itself would not have existed but for the grant of the subsidy, how does that interact with the sort of limited nature of the remedy and the compliance obligation with respect to Article 7.8?
Okay, wonderful. That was really, really interesting. I sense that Luca has a different view on withdrawal, and we can come back to that in the Q&A. I want to turn to the audience soon, but we have two more speakers, and they were each tasked with a specific issue or case. I want to turn to Clotilde first. We are focusing on subsidies on purpose. This is not a 2018 report, but a report that just came out a few weeks ago, but very, very interesting on subsidies, the China Price Support panel. Clotilde.
Thank you. Good afternoon, everyone, and thank you for organizing this event. As just mentioned by Joost, I will say a few words about the recent panel report in China, domestic support for agricultural producers. So it's subsidies, but in the context of the agreement on agriculture. And in that dispute, the United States challenged the level of domestic support that China provided in 2012, 13, 14, and 15 to its agricultural producers of corn, rice, and wheat. The panel did not examine the measures relating to corn because the panel concluded that the measure expired before the US request for consultation and request for the establishment of the panel. Just the panel examined the domestic support measures relating to rice, two types of rice, and wheat. The claim of the United States was that the level of domestic support provided by China to these producers of rice and wheat exceeded China's de minimis level of 8.5% for each of the products, and therefore that China failed to comply with its commitment level as included in its schedule of concessions. I'm not going to explain all the technical provisions of the Agreement on Agriculture. To make it simple, what the panel looked is whether for each product, the level of domestic support provided by China was exceeded or was below this threshold of 8.5%. There was not so much disagreement between the United States and China regarding the nature and scope of the obligation at issue. The disagreement was more was focused on the calculation actually. To determine whether this 8.5%, whether the domestic support was exceeded this 8.5% threshold. The Annex 3 of the Agreement on Agriculture define what market price support. And there are three elements in that definition. It defines market price support as to be calculated as using the gap between a fixed external reference price and the applied administered price multiplied by the quantity of production eligible to receive the applied administered price. Well, this is a very long definition, but we should simply remember that there are three elements. The first one, is this fixed external reference price. And I wanted here to emphasize one issue that the panel had to decide because there was a disagreement. The United States claimed that the reference price to be used was a reference price based on the year 1986 to 1988, while China claimed that the panel should use a price based on the year 1996 to 1998. And although the Annex 3 to the Agreement on Agriculture defined this fixed reference price by reference to the years 1986 to 88, the panel agreed with China that a dynamic interpretation should be followed, taking into account that China, in its schedule of concession, had referred to the base year 1996 to 1998. This is very important in terms of outcome of the calculation. It makes a huge difference if you look at the figures. The second point, second issue that I wanted to emphasize relate to the third element of the definition, and this is the quantity of production eligible to receive the AAP. China argued that the panel should define or the quantity of production eligible to receive the AAP as the quantity of production purchased. And this is what has been just indicated before. China tried to build this argument by referring to its schedule of concession, which also made a reference to the quantity purchased. However, the panel disagreed with that argument, and considering that because of the reference to quantity of production eligible to receive this administered price, that the quantity of production is not the quantity purchased, but it is and the quantity entitled to be purchased. And the panel also found support in the appellate body report in Korea beef on that point. So that's a second issue that is also, I think, very important and may have, an effect, an impact more broadly on, in terms of also of the notification made by members in which they have to take into account and indicate the quantity of production eligible to receive the AAP. I think that's all. Thank you.
Very technical, but I agree, incredibly important. So we've given an overview of some of the cases, especially in subsidies. It's really fantastic that Quinten is with us. Of course, you won't be commenting on any of these disputes because you left the US mission and now joined the WTO Secretariat. By the way, it's very difficult to get Americans on panels these days. They have to have left the mission, joined the Secretariat to be accepting our invitation. But we agree that you would try and summarize some of the reform proposals on the table, because it's no secret that one of the big issues in the ongoing tensions between, in particular, the US-China, subsidies, how do you treat state-owned enterprises, is a big issue. And I think Luca put it well. There's a sense that perhaps through appellate body case law, the bite of the subsidies agreement has been loosened, right? And you also mentioned it, although you agreed with the ruling that withdrawal means just getting rid of the subsidy, all of that creates a sense that perhaps the subsidy rules need reform. So if you could just sketch us some of the proposals on the table, and then we can turn to the audience for some questions. Quinten, thank you.
Thanks, Joost, and thanks for including me and including a question that I can comment on. I understood the question relating to reform, or review of reform proposals under the WTO subsidies agreement. I will lawyer my way around the question and come pretty far from it in the end, but we'll have a connection to the subsidies agreement and the current proposals. So there is, normally subsidies related negotiations would take place in the rules negotiating group, and there is a very active negotiation in that group right now, and it's on fishery subsidies. These would be new disciplines on fishery subsidies. It's a negotiation that's been going on for quite a long time, but it's been very active lately. It got some sort of new momentum from the Buenos Aires ministerial, where ministers said that they would attempt to negotiate new disciplines on fishery subsidies by the end of 2019. So that's very busy. There are lots of proposals. I won't try to describe them all, of course. But what's interesting, I guess, there to comment on is that there is the motivation for this negotiation is not strictly about the trade effects of these subsidies, which would normally be the case, but also about the environmental effects or the effect on fish stocks. So there's a sustainability aspect to this. So that may prompt some creative solutions to sort of fulfill the objective of those negotiations. Moving on from the fishery subsidy negotiations, there is one proposal to make a modification of the Annex 7 of the subsidies agreement. This relates to special and differential treatment. It's a proposal by the Central African Republic and the group of LDCs. It actually appears in the General Council. It very briefly, basically what it does is it addresses a concern of LDCs that are graduating from LDC status, which is an objective status, relates to the UN classification of countries as either least developed countries or not. And under Annex 7, we discussed earlier the prohibition on export subsidies. And Annex 7 identifies countries that are not subject to the export subsidy prohibition, so it's a pretty significant exception. The countries that benefit from this exception are divided into two categories, basically least developed countries, and then a defined list of countries that have a low GNP per capita income. And the proposal is basically to address a discrepancy between these two, or maybe interpret how to apply these two, which is that if a least developed country graduates and they're no longer on least developed country, but their income is still in the category of low-income countries, then they would continue to not be subject to the export subsidy prohibition. One interesting thing about this is that it is as I mentioned, an objective criteria. It relates to the application of special and differential treatment, and then moving out of that category of treatment. And there's a rule that the negotiators included in the subsidies agreement to accomplish that. And that leads me to another proposal, which is also in the General Council. It's a US proposal, which has defined some criteria to try to change the self-designation of developing country status in the WTO to something that it's based on 4 objective criteria, which they have identified as membership in the OECD, being in the G20, being defined as a high-income country in the World Bank statistics, and the last one would be to have more than 0.5% of global trade measured by imports and exports. There's a proposal. Obviously, it would affect the operation of the subsidies agreement because there is Article 27 of the subsidies agreement includes a lot of, or a list of special and differential treatment circumstances where developing countries are applied modifications of the rules that would apply to other countries. And if the status of any country were to be changed from developing country to not a developing country, then the application of the rules would differ. So this would change, in some respects, the operation of the subsidies agreement. There's been some discussion in the General Council on the proposal. There's opposition, and there are fairly detailed papers sort of outlining the various positions of different members on that proposal. This brings me to another proposal that is currently before the General Council, which would change in some ways or affect the operation of the subsidies agreement, and that relates to transparency. So this proposal was at some point during 2018 foreshadowed by statements that came out of what's referred to as the trilateral group. This is the trade ministers of the EU, Japan, and the US. They issued a statement saying that they intended to make a proposal, and eventually they did make a proposal to put some additional disciplines around transparency and notifications. In very short summary, the idea was that if there's a failure to notify, there will develop over time some consequences for that failure to notify, and these are described as administrative measures, and they would include things like the member who hasn't notified would no longer be eligible to chair WTO bodies. They may have to pay a 5% surcharge in their and their assessment to cover the WTO budget. And these funds might be directed to assist countries in overcoming their capacity constraints when it comes to notifications. As well, there would be other consequences in terms of mostly procedural elements of how countries participate in general council meetings, that sort of thing. There's sort of an elaborate structure in terms of the delays and the deadlines for the notifications and sort of being on the path to correcting it. But that certainly would be something that would relate to subsidies agreement notifications. The subsidy agreement is part of the proposal and part of the motivation for the proposal. Moving on from that, there's another not yet proposal, neither in the rules group or in the General Council, but again, it's been foreshadowed by this trilateral group of the EU, Japan, and the US, where they have, in a joint statement that was issued on January 9th, I believe, identified that they intend to forward a proposal to the WTO on the issue of industrial subsidies. And this gets a little bit more directly to the lead-in and to some of the disputes, some of the issues that have come up in the disputes. An earlier joint statement put some substance on what might be under consideration for this proposal. Obviously, we don't have a proposal yet, so I can't read out what the contents are. But looking at the earlier joint statements, it clearly states an intention to address concerns having to do with public bodies. Obviously, public bodies is an important issue because a subsidy is defined in such a way that it needs to be coming from either a government or a public body. So what is a public body is a crucial question in deciding what is a subsidy and what do the subsidy rules cover. There's a list in there that includes some considerations relating to what are market principles and market-oriented operation, and these principles would seem to be a foreshadowing of setting up some criteria for both state-owned enterprises and public bodies, and some, I guess, additional disciplines on subsidies that would derive from these kinds of entities. Thanks.
Okay, that's wonderful. Instead of giving panelists an occasion to comment, I'd rather turn to the floor, and please leave the option open for you to agree, disagree with what has been said. But I think we've covered a wide variety of issues, and I've learned quite a bit. It's really interesting to go into the substance. So to students, there's more to the WTO than the appellate body crisis. That there is actual reforms, substantive ones on subsidies, cases still coming out, so it's really useful to look into them. Let me see what questions we have, take a couple, turn back to the panelists on that basis. People will walk around with a microphone. We have 2 people even. So who wants to break the ice and go first? I told students to prepare some questions, so should I call on you as I normally do? It could be about the cases we've discussed. It could be about other cases. There's a couple of other cases that came out recently. Who knows? It cannot be that no one has a point. I see one hand up there. Well, perhaps that will stimulate others. Tom. It's in your genes. You're a journalist. Yeah.
Tom Miles, journalist from Reuters. Yes, I will not have a technical question, but I just have a sort of a plumb, dumb, stupid question. It seems like the Americans want the Chinese to completely overturn their economic model to conform with what the Americans see as being the requirements of the subsidies rules, or they want to change the subsidies rules to make the Chinese overturn their economic model and stop doing what they see as subsidizing their industry. I mean, how far removed are American wishes, do you think, from reality, what the Chinese are doing? Is there a major change needed? Are they asking for a lot? I'm just trying to get some perspective. Sorry, I know this is not about the cases you've covered in the past year.
It's okay. Giving the people here an opportunity to think about your question. any questions we can add to this? I see one over there, please. In the middle.
So Philippe Salah with the Canadian Mission, and so I'm somewhat familiar with the aircraft cases, as some people here know. And I must say that on my personal capacity, I also agree. I would say Canada probably also agrees with the decision of the appellate body on the meaning of Article 7.8 and the fact that once a member has withdrawn a subsidy, there's no longer an obligation with respect to the removal of the adverse effects of that subsidy. Natasha explained it very well, but you were also mentioning that, Mr. Rubini, you seem to disagree with this decision. I would be interested in hearing what you have to say and why you disagree, if that's the case, with this element of the appellate body decision in the S316.
Thank you. I am intervening because I am your student and to try to be helpful. Hearing the characterization on safeguards and the way that you try to depict the safeguards current standing, I was wondering whether the case of Dominican Republic polypropylene bags doctrine is still relevant for the future cases on the 232 measures. So in that case, just to point in, the standing of that panel was not clearly demanding the fact that the bound tariff need to be surpassed. So in that sense, I would appreciate whether you can comment on that and where that standing, and in particular the reference to the estoppel principle, might be useful to the 232 cases that we are going to see in the next couple of years.
Perhaps we can turn to the panel and then see whether there's a second round of questions. We had a question on China and what can we expect? Do they have to change their entire regime? Perhaps a question for Luca on withdrawal, why you disagree, and then a question on safeguards. Whoever wants to take that one. Who wants to tackle the China issue? Luca? Yeah, why not?
Let's put it this way. I think that one of the political motivations to reform the rules is certainly how to tackle the Chinese model. It's an issue of interface between various different systems. Having said that, I would not characterize the type of law that might come out as a kind of punishment of China or forcing China to completely change their model. My gut feeling is that anything is going to come out in this proposal soon. It might even be something about resurrecting something that was already there in the SCM agreement and has gone. For example, the presumption of civil prejudice under Article 6.1, which is something that the US themselves in 2007 put forward as a proposal in the Doha round, not with the language, but hardening a little bit the prohibitions. But this is not necessarily only targeted at China, something that you would find also in other legal systems that tackle subsidies like the EU state aid system. So I would not really characterize that legally or as an output. Sorry. So you didn't hear anything.
No,
okay. Okay. So that is about the question about China. With respect to the adverse effects, I have to admit I'm still thinking about it. But my gut feeling is that the panel was more correct. Why I'm saying that? I'm thinking aloud. So, something I'm saying maybe I may regret it in the future. But I think that one of the main purposes of having subsidy rules or why subsidies may be a concern for the WTO is that they could cause negative spillovers, adverse effects. So this is the main thing you have to tackle. So it doesn't really mean whether the subsidy is gone, is there, it is extinguished if the effects which are linked to that subsidy are still there. To put it another way, it is a responsibility of the country, the government that has taken the subsidy to ensure that all these adverse effects are gone. I might even go on and thinking we have this obligation for actionable subsidies, remove adverse effects or withdraw the subsidy. Is it really an alternative which is left completely to the choice of the member? They can pick and choose whatever they want. Or is it simply we should look at a kind of differential remedy? We are talking about actionable subsidies. They are not as bad as prohibited, for which you simply have to withdraw the subsidy. Here we are giving you another option. Simply remove the adverse effects. But if this is not enough, this is something I'm adding, you must also withdraw the subsidy. And I'm adding something more, and this is not something that comes from myself, but from Simon Lester. Is it also possible that the obligation to withdraw the subsidy maybe includes in itself the obligation to remove the adverse effects?
Just to follow up on this, because I heard Quentin speak about the fisheries subsidies, the negotiations there, which made me think of, well, for a fisheries subsidy, or as you said, thinking about environmental effects in the first place, not so much trade effects. Plus, if you have to withdraw a subsidy for, say, the building of a boat that happened 5 years ago, what's the point then if we just apply the usual remedies also to fishery subsidies? It may be weak, as you were kind of implying, in the traditional subsidy sense, but completely weak or non-existent in many of the fish subsidies. Have there been proposals to kind of deal with the issues that he identified? Sorry to put you on the spot.
Sure. No, it's quite all right. In fact, as I said, it's been a very active negotiation in the fishery subsidies area, and a lot of the issues have started to be explored. Some of the members who are participating in the negotiations have started to think about whether or not there needs to be some different treatment of remedies in relation to these subsidy disciplines. Obviously, the object of the negotiation is to discipline a certain subset of subsidies, and that's their focus. But as I mentioned, the motivation has a lot to do with sustainability of the fish stocks. So there is some thoughts about, is there, in order to achieve that objective, are there additional kinds of remedies that might be put in place that don't just track trade effects, which is the normal course for remedies in dispute settlement for all of the other subsidy disciplines that we have.
Hannes, you wanted to say something on the China question? Be careful, there's people from the Chinese mission watching us.
I'm always never careful. Now, what I would like to say is, I mean, your question was so wonderfully general. And in general, I would say, no, the US don't want China to overturn their economic model. It's their sovereign right to have an economic model. There are no rules in the WTO to have a certain economic model. The problem is reverse. The rules are made in view of a certain economic model. That's the problem. I give you an example. I happen to be a negotiator in the Uruguay round. And Uruguay round, you might know, went from 86, got active in 89, and was concluded in December 93. So the whole period of the changes in the Eastern Bloc, sort of the disappearance of the USSR, all these countries trying to join Western alliances, the EU gave up planned economies, and so during these years we thought, and there were proposals to that end, should we have rules on economies in transition? At the end of the day, we said no, because we know how they are going to develop. They will all develop into market economies, so that's it. And I think there was the same spirit when there were the accession negotiations with China. And everybody expected China to develop in the same way as they were developing since the late 80s until 2001 when they joined. But that didn't appear to be the right prediction. China at some point in time said, no, we're not going to sort of liberalize all that. We want to be more in control of our economy than other members would be. So it's not about forcing China to change the system. It's about the question, are the rules sufficient? And this came up in particular in the context of this clause in Section 15 of the accession protocol of China, where the clause expired in 2016, and many, for a long time, interpreted that as, from then on, China is a market economy. And you know, in 2001 and in 2003 and 4 and 5, including me, nobody thought that this wouldn't be an issue because China would develop and they would get their market economy status long before 2016. So it is the development of China which has turned out to be the problem. And that's at least for certain rules. For other rules, maybe it's more an issue of that China is opening up and giving the same treatment to foreigners in their economy than they enjoy in other economies. So these elements play a role, but it's not about the right of any country to decide what model they want.
Natasha, you wanted to try and answer the last question?
Certainly. So I think that there has been clarification in the Indonesia Safeguards report that does bear on the continued relevance of the prior panel report. To me, the critical issue is the linkage between the two constituent elements of a safeguard. Now, I find it interesting that it took until 2018 to clarify what is a safeguard measure, but the fact that it's the obligation that is suspended, that must be suspended for the purpose of for the protective purpose, that those constituent elements, the linkage between them is essential to define what is a safeguard is important, because it can't just be that there is a measure that in some respects suspends an obligation. So even in the Indonesia case, which I think is similar to the prior case, the suspended obligation was taken to be, in the application of the safeguard, the idea that MFN was suspended because certain members were exempted from the application of the safeguard. And the appellate body has clarified the suspension of the MFN obligation in applying the safeguard. The purpose of that suspension of the MFN obligation was not protective. It was in fact, you know, to meet certain requirements under the Safeguards Agreement, but it didn't have the required purpose. And Article 19 establishes that a safeguard measure is a measure where you suspend the relevant obligation in order to safeguard your industry. You can't just have an additional aspect of the measure that breaches a relevant obligation and then separately an intention to protect your industry, and that you can sandwich the two together and consider that to be a valid safeguard measure. Two other things that I just want to highlight about that particular case, including based on Hannes's comments. One is that, yes, while the appellate body has commented on particular aspects of the evidence that is relevant to determining how a member saw the safeguard measure and notified the particular measure, etc. The outcome of that case, to me, the takeaway from that case is that a safeguard measure is something that can be objectively determined on the basis of whether it has those two linked constituent elements. And I think, importantly, other aspects that, including that you mentioned in terms of has there been a determination of serious injury, that goes to the question of whether you have a validly applied safeguard measure, not to the question of whether the measure is a safeguard measure itself, which is an important distinction. And then just from a systemic importance perspective, more generally to dispute settlement system itself, That case also served to highlight the importance of third-party participation for the system, because in that particular case, all three participants before the appellate body shared the view and had a common argument that the panel was wrong to have found that the measure at issue was not a safeguard. And it came to the third participants to ventilate this broader interpretive legal questions for the appellate body to consider as part of the proceedings. So I just wanted to comment on that. And very quickly, just in response to Luca, I just wanted to highlight that there is a distinction here between original proceedings and compliance proceedings, and I think that that's important to bear in mind in terms of what is the scope of Article 5, this obligation not to cause adverse effects through the use of a subsidy, and then what is the scope of Article 7.8 from a compliance perspective. And I think it would be useful just to highlight to this end that for the purposes of Article 5 and to allay your concerns about the ineffectiveness of where the law maybe has ended up, the appellate body has made clear that a finding of present subsidisation isn't necessary to establish that a subsidy has caused adverse effects, but when you are looking in the context of compliance proceedings and not original proceedings, the focus of Article 7.8 has to be on the continued existence of the subsidy itself.
Okay. Clotilde, do you want to add something? No? So let's have a final round of questions, comments, input. Please, the gentleman over there. If we have microphones, just one over there. Oh, sorry, you had please go ahead. You have it already. I'm sorry, I didn't see it. So one question there, a second one there. If you want to pose a question, raise your hand.
Yeah, thank you very much. I'm Gautami Silva, the ambassador of Sri Lanka to the World Trade Organization. Hi, Gabriela. Two questions. I do have two questions. One actually to the gentleman. Now, it seems to me the two cases on actually of Brazil and Indonesia, particularly on Article 3, paragraph 8b, it has really overshadowed the real effectiveness of this provision, because I see that a lot of countries tend to use this article because they are taxing that income is of course used to support the domestic industry and in order to sort of maybe increase the production or to really overcome the structural limitations that they have in. So the thing is that as long as their production does not distort the domestic market, and so as long as they really ensure the disciplines are, subsidy government disciplines are protected, I think it's a legitimate right of most of the developing countries to use that article to really provide subsidies to the domestic producer. So I think because these two cases haven't really, because both countries, I think in one hand they were maybe compliant with Article 3.8 paragraph B, but they were in violation of the subsidy agreement. So that has really overshadowed the effectiveness of this article. That's what I feel. Maybe you all can comment on it. And the second one is on the safeguard provision, the dispute which India, I think, was involved. Because to my mind, of course, in this measure there was a lot of water between their applied level and the bound level. So instead of, now what I learned from Gabriela, sorry to say, and always the countries can actually raise their applied level up to the bound level. So that is a legitimate right. And if that protection is not adequate, only they'll have to invoke the safeguard agreement. So that's the way that I have understood about the agreement. But in this case, and I really asked this question from India, and during our bilateral negotiations, so you had that provision to. So no, the problem we had is that we were not sure that margin would be adequate for us to really offset the injury. So that's why they had to really visualize this situation well in advance and then go for a safeguard measure. So that is something I thought would be useful because my understanding is that always you have the freedom to raise your duties up to the bound level if you are applying a low level. And so those are my comments. Thank you.
Thank you. So one more question over there. Anyone else has a question? I know you all want to have a drink. Yeah. Please. Yeah, two quick ones then.
Thank you, Justin. I'm Yusung from the Chinese mission, and I think I'm not going to have any questions, but just some comment. And firstly, regarding the issue of withdrawal subsidy, and I would like to remind a participant here that actually members have a quite intensive discussion on this issue. I mean, during the rules negotiation almost 10 years ago, and actually members have come to some discussion solution on this withdrawal subsidy, and it's, I think they've been reflected in the chair's text. And but I'm quite agree with the solution in the panel report and appellate report, and we think that the withdrawal subsidy means that withdraw the subsidy itself, not the consequence or effect of subsidy. So until members have come to negotiation, I mean, to some other principles or so other texts, so I think that the panel and the appellate board should, I mean, limit its jurisdiction within the text of the agreement. So I think that this is quite clear as fundamental issue. And second, I think that I'm not going to respond to the so-called China model issue because it's quite, I mean, I think it's unrelated with today's, discussion. But I think that today's is regarding the annual update on WTO dispute settlement. And I think one aspect is also very, very important is a kind of the implementation of dispute settlement resolution of members. Because if you go to the true DSP meeting, you have seen that a lot of agenda items regarding, surveillance of members' implementation of dispute settlement rulings, because it is also a very, very important aspect. So probably, we should include probably in the next year's, discussion about how the situation and members implementing the rulings and how the record of different members and how to improve that. Thank you.
So one last question, please. Yes.
Thank you. Amar Breckenridge from Frontier Economics. I have to say, as an economist, I always find it fascinating to hear the deliberations of panels and appellate bodies as to what constitutes a subsidy or not. From an economic point of view, a subsidy happens when you transfer risk from private agent to the state. That lowers the required hurdle rate of return. So projects that weren't going to happen, the supply curve gets pushed out, and you have your subsidy. Yet the cumulative effect, it seems to me, of jurisprudence of the last few years is that you have a remarkable number of instruments now that look, walk, and quack like subsidies, but are actually not subsidies in legal terms. So I was just wondering what the systemic effects of that are. And it ties into the China question, because the China development model is essentially for the state to bear a lot of the risk that it feels the private sector is not in a position to bear given its level of development.
Okay, who wants to respond to any of these questions? I saw you wanted to say something. Yes.
On the safeguard question from about India, and we've come across this over the years again and again. The developing countries who have very high bound rates, and then they have a choice. And I think it is really a choice what they do. They can decide to raise their tariffs, their ordinary tariffs, and they can decide to use a safeguard measure. That's not to the WTO or panels or whatever. It's the question of which instrument you want to use, and normally there are domestic reasons why you use the one or the other. One is maybe a legalistic one. In order to raise a tariff, you might need a decision of your parliament, while in order to impose a safeguard, you might have an administrative procedure, which is easier, quicker. The other thing is, and that may be rather a policy consideration, the sort of Ministry of Economics or whoever is in charge of that is subject to pressures from its domestic industry. And they would probably prefer to take a measure which is limited in time, and where there is a phasing out, and where they have a process, where they have an investigation which is somewhat objective, and prefer that to a mechanism which is maybe just finding a majority in Parliament for raising a tariff for all times. Sort of to get rid of that increase in tariff is maybe very difficult. So all these considerations enter into that, and then you do the one or the other, and I hope I could explain what the consequences in legal terms of doing the one or the others are.
Okay, the last word for Luca, because you are the one person not living in Geneva. You came especially for the event, so you have the last word.
I might take the point about Article 3(8)(b) that was overshadowed. I mean, in this case, I mean, I think it's a balanced case, because in the end, it is simply saying that you cannot use that exception to cover tax measures, but any other type of subsidy domestic subsidy would be covered. But this is something which would have been clear even before the case. You cannot use that to protect local content requirements. But apart from that, all the other domestic subsidies are clearly covered by that type of measure.
Okay, we ran a little bit over, but I'd like to now invite you to a little reception we have organized. And for many, many years, King & Spalding has been sponsoring this, for which we are really grateful. But before we move, it's just one flight of stairs up for the drinks. Join me in thanking our panelists. The first two speakers are no longer here, but thank you so much for being here.